Je voulais m'amuser à essayer le marteau. Alors, yeah.
Can we remove our masks? Yes, for a francophone. It's really lovely to hear no translation because that often happens to us. I just wanted to make sure it wasn't my turn this evening. Well, I thank you all for being here. I'm advised that we have quorum, so we can begin our proceedings. I believe we had motions before us. If anyone has a motion, I believe you had a motion.
We being Mr. Brock and I have a number of motions. I don't know what order you want to bring them in. We can talk about them in order. We can go back and forth. I'll just give you an overview of the ones that we have in our.
Point au règlement, Monsieur le Président. Je pense qu'on fait une motion.
A point of order. I think we're supposed to do one motion at a time. Yes, obviously. But I understood that Mr. Motz was asking which motion he should put first. I have no preference. You can go in any order you wish.
I will go to the first motion. It was presented last week. I guess some of the other ones that we have are amendments to the motions that our friends across the way have presented. The very first motion that we can talk about, I suppose, would be the one introduced last Monday, would be the legal counsel, and I will present a revised version of that, and can speak to it. Here's. Thank you.
Okay, thank you.
And Chair, just along with the lawyer motion, if there's some hesitancy about the lawyer motion based on we don't know what we're going to do or how we're going to do it, we also have a motion on kind of the scope of what we should cover and what a report should look like.
Je crois que vous allez la lire, la motion.
I believe you'll be reading the motion first, and then it can be explained.
Je crois que tout le monde a eu sa copie, donc je vous laisse la.
I think everyone has a copy, so you have the floor if you wish to read your motion.
Thank you, Mr. Chair. The motion is that in light of the unprecedented and complex issues associated with the declaration of a public order emergency, and with the view to discharging adequately its serious responsibilities, the committee requires the assistance of legal expertise independent of the Government of Canada to be provided by a lawyer who is well versed in emergencies law and who is thoroughly familiar with national security and intelligence concerns, and therefore retains the services of a lawyer who satisfies these criteria to be chosen by the committee as legal counsel on such terms as agreed on or as agreed by the committee. Mr. Chair, you will. I can speak to it after your.
Ouais, je crois que, sauf erreur, il y a.
Well, I believe, if I'm not mistaken, there's a motion for amendment on the part of Ms. Bendayan. Well, no, I'd like to move something before Madam Bendayan. Yes, I believe my colleague Ms. Bendayan and another colleague have this. Our position on the issue. I'm going to go to English. Mr. Chair.
Proposition for the three Liberal members on whose behalf I'm speaking is that the basis of Mr. Mott's motion is about, and I track this language because it's in both the original and the second version, is that requires the assistance of legal expertise, quote, independent of the Government of Canada. And what we view with respect to this motion is that it seems like an implicit or veiled attack on the impartiality of civil servants who serve this country. And it is our view that rather than embark upon the retainer of independent legal counsel and the process that would undertake, the time that would take in terms of eating up time that this committee could otherwise better spend on actually studying the issues which we've been charged to study pursuant to the House motion, and undertaking the expense of such a retainer, that we use the good offices of the civil servants who are employed to do exactly that, of which there are two options. There are Department of Justice counsel, and there are also counsel that serve the Parliament of Canada, and there I'm referring to the law clerk to the House of Commons and the law clerk to the Senate. So it is our general proposition that this motion is not suitable, and we would be voting in favor of its defeat in its entirety. Thank you, Merci,
Monsieur Virani. J'ai Monsieur.
Thank you, Mr. Virani. I now have Mr. Green, and I have to put my glasses on, and Mr. White. But I said to Mr. Motz that I would allow him to speak to his motion, and that was my mistake, Mr. Motz. But I will give you the floor so you can explain your motion.
Thank you, Mr. Chair. While I appreciate the comments from Mr. Virani, I think it's important to recognize that we all know that the declaration of the Emergencies Act by the Governor and Council was unprecedented in Canadian legal and national security history. And the use of the Emergencies Act, the orders and the regulations established in the Act, and their enforcement are all subject to various legal tests and thresholds that had previously never been applied or tested in any way. We know that the advice provided by the Department of Justice and supported by intelligence and analysis from Canada's National Security and Intelligence Committee formed the basis, or national community, formed the basis for the Cabinet's decision to invoke the Act and what measures were necessary. However, I'm of the opinion that the government has not clearly articulated the legal basis for these decisions or how the evolving facts or threat picture supported the imposition of such extraordinary measures. In short, it's possible that the strengths or weaknesses of the government's legal positions have not yet been tested or assessed by legal experts except those within the Department of Justice. Now, understanding this particular threat and these legal thresholds, it is critical, in my opinion, to this committee's task in reviewing the powers, the duties, and functions exercised pursuant to the declaration and as legislated. Unfortunately, the development of and reliance upon confidential legal opinions based on potentially classified information known only to Department of Justice lawyers and national security officials and agencies they advise has proven problematic in recent years. And so a fact highlighted even in the Supreme Court of Canada or in the Federal Court of Canada. So therefore, I believe it's imperative that this committee benefit from outside independent legal advice and analysis for us to be able to do a fulsome and complete review of the evidence that will be presented to us and to advise us because this is a major undertaking that many of us around this table may not have the experience necessary or the expertise necessary to maybe seek certain witnesses or to advise or to ask certain questions. And I think it would be important for us to be able to have someone who meets the threshold of the skills described in the motion to be able to give us and Canadians the most transparent and accountable view of this invocation of this act.
Merci, Monsieur Motz. Monsieur,
Thank you, Mr. Motz. Mr. Green.
Having read the revised motion, and certainly in keeping with the spirit of having a diversity of opinions around the table, I would put to this committee that I am open to having at our disposal outside legal counsel. I would suggest that we may find common ground by not limiting it to or having it be the only legal counsel provided to this committee, notwithstanding the fact that we ought to have ample time to invite the appropriate witnesses and guests who would be able to provide expert testimony at our request. And so I think, like in keeping with the spirit of having a balanced approach to the legal interpretations, I certainly don't want to take anything away from our existing legal counsel within the public service, but would leave open to the pursuit of outside legal expertise, noting that that process will likely take some time and some vigorous discussion to come to a consensus about who that person might be, and could veer us off of the material course of what we're pursuing. And so that would be my caution, is that in the selection process of that, noting in our routine motions, Mr. Chair, that we no longer have subcommittees. We have basically agreed that we're going to keep everything as a committee of the whole, that I wouldn't want this process to be our first major roadblock to coming to some kind of work plan consensus. And so I would just state that if it is the intention and the spirit of the mover to bring outside legal counsel in addition to existing legal counsel that we have, that many names be put forward, and everybody around the table would have the opportunity to seek forward adequate expertise, subject matter expertise, and then as a committee we would come to a consensus. And the last point that I would make on this is that if as a committee we deem that process became an obstruction in and of itself, that we could at a potential later date decide to abandon that process for the sake of the committee. But in this moment, I would support the mover's intention on having outside legal counsel to add to the diversity of expertise around the table. Thank you.
Monsieur Green. Monsieur Harder.
Mr. Harder, please.
You go first. Thank you very much, Chair. I believe
Oui,
the discussion...
J'avais oublié d'indiquer Monsieur White. Je vois
Monsieur-
I forgot. Senator White?
Il était avant moi.
Oui, j'ai...
Yes, he was before me. I understand. My mistake. Senator White.
Look, thank you very much, and I'm actually I want to thank my newfound friend, Mr. Green, because that's my perspective is that I don't want us not to consider bringing in outside legal counsel. In fact, I believe we may need that. But I would like to first see the scope of where we're going. A friend of mine once told me never ask a lawyer to do work for you until you tell them what work you want them to do. So. Because they could cost us a lot. So I would like to see us come to an agreement that that outside legal counsel may be appropriate, but I don't think we should hire an outside legal counsel until we actually see what the scope of the work is going to be. So, and I think that will allow us to get that out of the way.
Monsieur Harder, oui.
I'll be brief because it's
Thank you.
the spirit of Senator White. I think this discussion is premature. If I am open to the notion of outside counsel, should we, in the course of our work, identify that as a need, but let's deal with our scope, get off and running, and start some work. And if we find that we need a particular expertise that can be found in outside counsel, let's do that at that time. So outside counsel if necessary, but not necessarily outside counsel.
Merci. Monsieur Carignan.
Thank you. Mr. Carignan, Senator Carignan. Thank you. I also think we should have outside counsel. We're a bit like a commission of inquiry. And every time this kind of commission sits, it always has lawyers who advise them as to their work. I believe our work right now is rather like that kind of commission of inquiry. But I'm not sure that we should wait to mandate this, because when we need it, there may be a delay. A period of time we'll have to wait. Because they'll need time. A lawyer, an outside lawyer, would need time to look at all the facts. And when there are questions that are current, that are raised spontaneously, it's much easier if you have legal advice. And if we wait for a problem before we put a question to a lawyer, well, we might have to wait a week or two, and that may lead to delays. So I rather think that we should have the mandate now. Thank you, Senator.
Thank you, Mr. Chair. Ultimately, I think what I will be proposing is that we adjourn this debate. I think perhaps this is premature based on what I'm hearing from committee members. But I just want to add this commentary. For the lawyers on this committee, there's such a thing as bias, and then there's the reasonable apprehension of bias. And no one on the Conservative team is impugning the integrity and the professionalism of the federal civil service. But ultimately, depending on how we frame this study and the scope of the study, we may be getting into areas that directly relate to the advice that legal counsel gave to the government. So in that instance, it would be highly, highly inappropriate, because it would be an actual perception of bias, to consider the independence of that type of evidence for the purposes of this committee. So I think in those circumstances, it would be a wise, prudent move to consider outside counsel. I mentioned that, Glenn.
Monsieur Brock, est-ce que je...
Mr. Brock, are you moving adjournment of this study? Is that what you're saying?
Yes. No, the motion, not the study.
Non, évidemment.
No, obviously.
Last week.
Party. Non, je veux dire, vous faites une motion pour...
No, you're moving that we end the consideration of Mr. Motz's motion. I still have Ms. Bendayan and Mr. Virani. So, yes, if there were a motion to adjourn, that would have to be done later. So those who are in favor, shall we do this by a show of hands? Is it unanimous? Does everyone agree? Unanimous?
Oui, le débat sur votre motion.
Yes, the debate on your motion. Your motion, not the committee debate, but your motion. There is consensus? Well, I say we should adjourn the debate on Mr. Motz's motion. And Mr. Motz, you have the floor for the following motion.
Oui.
Avec votre permission, j'aimerais rebondir.
With your permission, I'd like to get back to one of my colleagues' comment of Senator Carignan. He referred to the fact that our committee's work is somewhat like a commission of inquiry. I'd like to specify that the Emergencies Act, under Section 3, which says inquiry or investigation, well, that's one, but our committee is distinct. Thank you, Ms. Bendayan. Mr. Motz? Yes, please go ahead with your next motion.
Thank you so very much, Chair. I'm proposing the following motion, that the Joint Committee frame its primary study. Oh, sorry, I'll just wait until just give me a moment, sir. I'll wait until the distribution comes around. I think everyone has it. So, if I may proceed then, Chair?
Je crois que tout le monde l'a eu.
I believe everyone has the motion. For those who are online, we have sent it. Senator Carignan, have you received the motion?
Oui. Oui.
Yes, I have. All right, thank you. Go ahead, Mr. Motz.
Thank you so much, Chair. The motion then will read that the Joint Committee, frame its primary study and its final report under the following themes. Bullet 1, the events leading to invocation of the Emergencies Act. Bullet 2, the rationale for invoking the Emergencies Act and the alternative courses of action available. Bullet 3, the legality of invoking the Emergencies Act. 4, the choice and necessity of the regulations and orders adopted under the Emergencies Act. Bullet 5, the constitutionality of those orders, or the regulations and orders. And bullet number 6, the use made of those regulations and orders.
OK. J'ai le nom de Monsieur Green.
I have Mr. Green's name. I think Senator Harder also wants to speak, but Mr. Green?
I think that this is a really solid start and a really clear pathway for a work plan. I would, however, like to move an amending motion to include that the Joint Committee frame its primary study and its final report, including, but not limited to, the following themes. And that would give us the flexibility of perhaps pursuing topics that are unbeknownst to us in this moment, but use this frame as the basis for the work plan, but not keep it limited to that should other courses of interest or study present themselves given new information that's presented on the points in which are brought forward.
Monsieur Mott, vous êtes d'accord pour un gentleman?
Do you agree, Mr. Motz, with a gentleman's amendment?
Donc, la motion va être amendée comme le suggère Monsieur.
So the motion will be amended as suggested by Mr. Green. And now, Senator Harder, you have the floor.
Mr. President,
Thank you, Chairman.
with the early bullets of this motion, I'd like to speak to that. We know under the Act there will be an inquiry, and the scope of the inquiry is very broad and defined to look at many of the circumstances of certainly the first three bullets as well as the others. My reading of the Act is that this parliamentary committee has as its focus the implementation of and actions taken under the Emergencies Act, not a review of the legitimacy of of either the government's invocation of the Act or Parliament's vote on the Act. So I'm reasonably comfortable with the last three items, but the first three I think intrude on the jurisdiction of the inquiry. I think our work would be helped if the government were to announce the inquiry soon, so that its work and scope of its work could be clearly defined and our work could be complementary to that. But I'm afraid that we are killing more than our mandate with this motion.
Merci, Monsieur Harder.
Thank you, Senator Harder. The clerk has just brought to my attention that I committed a beginner's error. I forgot to ask about Mr. Green's amendment. I'd like to know if someone among us has any objection to Mr. Motz's motion being amended as suggested by Mr. Green. Does anyone object? No? Yes? Mr. Varani? Well, I believe that before we decide if Mr. Green's amendment is a good one, we need to debate the motion in its entirety first.
Order?
Juste une
Point of
minute.
order?
Just a moment, please. The present debate, the debate we began, was on the motion as amended.
Juste au but de vérifier, parce que j'ai...
Well, I'll have to check. I believe that Mr. Motz agreed with the amendment. I don't know if the entire committee was in agreement with the amendment. It's possible that I've made a mistake. If it is the case, if the amendment hasn't been decided on, then the debate is on the amendment until the committee makes its decision. That's what I understood, but I may have made a mistake. So can we agree that the debate will be on Mr. Green's amendment? Yes. But do I have the floor? Well, actually, it's Senator Harder. So thank you, Senator Harder. You have the floor. Well, overall, I don't agree. But my Liberal colleagues may not agree to the amendment.
As Senator Harder was referencing, I think it's really important that the committee draws reference to and that the record reflects what Section 62.1 and what Section 63.1 actually say in the statute. So 62.1, which relates to us, the Parliamentary Review Committee, says, and I quote, "The exercise of powers and the performance of duties and functions pursuant to a declaration of emergency shall be reviewed by a committee of both houses of Parliament designated or established for that purpose." So that is this committee with representatives of the Senate and members of Parliament. And what we are meant to be looking at is, quote, "the exercise of powers and performance of duties and functions pursuant to a declaration of emergency." In contrast, and this has come up in respect of the debate we were having just about 10 minutes ago, there's also contemplated an inquiry, which has to occur. And that inquiry is entrenched in Section 63.1 of the same statute, and I'll read it. It says, quote, "The Governing Council shall, within 60 days after the expiration or revocation of a declaration of emergency, cause an inquiry to be held," and here's the important part, "into the circumstances that led to the declaration being issued and the measures taken for dealing with the emergency." And the key point here, Mr. Chair, is that the inquiry has a retrospective and a prospective element, whereas the review committee does not have a retrospective element whatsoever vis-a-vis what happened prior to the invocation of the declaration. It speaks simply to the exercises of powers and performances of duties under that declaration. So I think Senator Harder's point is very well taken, because the first three bullets of what Mr. Motz is proposing are retrospective in their nature and clearly outside of the scope of Section 62.1. It's open for debate whether the remaining three, and these being the choice and necessity of regulations, the constitutionality of those regulations, and the use made of those regulations, fits squarely within 62.1. So that's my first general point, Mr. Chair. The second point I would have is that it may be premature to be looking at this without the advice and input of people experienced in interpreting these types of provisions, so that people aren't taking my word for it or the word of any of my colleagues. And by those people, I mean perhaps hearing from the law clerk of the House of Commons or the law clerk of the Senate to help us with scoping the study before we take a preliminary decision on a motion without having the benefit of their interpretation of 62.1 and 63.1. So I will leave it at that. I would also say, actually, as a further submission, when you look at the context of the motion, so now I'm referring to the motion that was passed in the House of Commons, on which 6 of us, I guess, voted. It says in subsection A, the very first paragraph of that motion, it says, pursuant to subsection 62.1 of the Emergencies Act, that's the section I just read, a special joint committee of the Senate and the House of Commons be appointed, quote, "to review the exercise of powers and the performance of duties and functions pursuant to the declaration of emergency." Again, it is not retrospective in nature. It is contemporary, what happened when the invocation was declared. So I'll leave it at that. Thank you, Mr. Chair.
Merci, Monsieur Virani.
Thank you, Mr. Virani. Now, Ms. Bandayan, and then Mr. Brock, Mr. Motz, and the Senator. Yes, I'd rather speak after my colleagues. So, Mr. Brock.
Mr. Chair, this is not an exercise of judicial interpretation of a statute. That is not our responsibility. And while I have the utmost respect for my colleague, Mr. Virani, I respectfully disagree with his literal interpretation of the language of this particular statute. An argument could be made. I do not dismiss his argument, but our mandate is to provide clarity to Canadians, not necessarily just taking a look at a snapshot in time from the date of invocation and reviewing all the circumstances prospectively forward. In my opinion, sir, with all due respect, it would be a derelict of our responsibility without taking a look at all of the circumstances that created the emergency in the first place. In our view, no one can reasonably be expected to review the declaration without looking at the reasons for the declaration. If the emergency proclamation was unlawful, it follows that the exercise of powers would be equally unlawful. Thank you.
Merci, Monsieur Brock. Monsieur Mo-
Thank you, Mr. Brock. Mr. Motz.
Thank you, Chair, and I won't add much more than the eloquency of my friend, but I would agree. As I read this once I realized that was going to be on the committee. To me, the exercise of powers is exactly, in order to understand how those powers were exercised, you have to understand the circumstances which led them to believe they needed to be exercised in the first place. So Canadians, and you have to look at this through the eye of a Canadian who is concerned and watching what we do on this, no one can reasonably be expected to review this declaration and whether it was appropriate or not without looking at the reason behind the invocation in the first place. And so, if the emergency's proclamation was unlawful, it follows then that the invocation itself or the exercise of powers would be equally unlawful if that's what the conclusion is. So, as Mr. Brock said, it would certainly be reasonable for us to have a full view of those who made the decision in the first place to invocate this Emergencies Act. How can we possibly say whether it was appropriate or not without having the same set of circumstances that they looked at to make their decision that we also look at to make our decision? And so I would respectfully have to disagree with Mr. Varani and suggest that there might be other bullet points, if we will, about this motion that we can add to this to give us a fulsome. But I guess one way to look at it is, if you're looking at it from those of us who've been a law enforcement perspective, when you look at an arrest, the lawfulness of that arrest is looked at in its totality, the reasonableness of it, and if you're doing a search, was it a warrantless search? Was that warrantless search reasonable? You have to look at all the factors that led to that conclusion, and frankly, for me, I can't make a fully informed decision on whether this was appropriate or not without seeing all the facts that everybody else at that time used to make that decision.
Merci, Monsieur Motz. Monsieur Carignan.
Thank you, Mr. Motz. Senator Carignan. Well, what I have to say is similar to what my colleague said. If I want to assess the committee's mandate and study the exercise of powers, I can't really verify how reasonable this is. Why did we get this? How did we do it? Was our power too broad, not broad enough? If I don't have the necessary information from before as to what led to the declaration of emergency, that would be a question of reasonability and legality. We cannot assess that abstractly. You're talking about a certain date Y, date Z, and we have to look at the context in which the decision was made, and we have to look at the facts which led to the rationale behind the declaration of emergency. And that would mean trying to decide on the reasonableness of this, because we would be lacking an entire part of the story. And you can always make a mistake. So I think it would be wiser to look at what led to the declaration of emergency, and that would allow us to decide on the reasonableness of the decision taken. Thank you, Senator. Mr. Green.
Thank you, Mr. Chair. I want to reflect on this first as somebody who in the House voted to support this Emergency Act, somebody who is responsible for reporting back to my community about the rationale, the basis of the Act. From my perspective, making a decision based on information that was only made available to the public, not having had the privilege of having the inside information that the government would have had to come to this conclusion. I look at the work plan that's been presented before us, and I've heard the comments of Senator Harder, and where I could only find agreement with is perhaps on point number 3. I would not claim to be a legal expert. However, I feel like exploring the legality of the invocation would be to the benefit of the public. I would state that this legislation, as drafted and contemplated in its time, was left ambiguous. And I would suggest that there's probably case law, although I'm not a lawyer, that would suggest when legislation is unnecessarily ambiguous, liberal interpretations ought to be had on the legislation to provide fairness for the people who are pursuing it. I feel like in the comments of my friend Mr. Varani, he was generous in his overprescription of how he interpreted what is before us, which on its face looks fairly ambiguous. And so from that perspective, points 1 and 2, I can't imagine a scenario that we could understand the actions being necessary or proportionate if we don't examine the actions leading up to it. The rationale, I would put to this committee that at its height, this country was experiencing a crisis of confidence in our democracy, in our government, in our public safety frameworks. There was a crisis of confidence in local policing, provincial policing, national policing. They were seen to be compromised in the events leading up to the invocation of this act in a very public way, live streamed for the public to see. And regardless of where people are on this, in terms of whether they supported or they didn't, whether they were in support of the actions that took place or not, I believe that Canadians deserve to have a fulsome exploration of the topics at hand. And I would suggest to this committee, and caution this committee, in fact, that the crisis is still a very clear and present danger, that if we don't act with the kind of care and thoroughness, and by thoroughness I mean not over-prescribing or unnecessarily narrowing the scope of our exploration of this topic, we will be revisiting this type of crisis in the very near future. And I can't state enough that in supporting this Emergency Act, as a member of Parliament, I believe there to have been a national crisis. I don't think that crisis happened to have gone away. I think that we're facing other crises around the world, but it doesn't take away from the fact the cynicism, the lack of trust, and the erosion of faith in our democratic institutions is still very much a topic at hand. And so, you know, what I would put to this committee is that if we rush to defer our responsibility, recognizing that this legislation is not clear, then we risk a review process that is so overly legalistic that it lacks social political context for the average Canadian to fully understand and unpack what happened. And what I mean by that, I mean this heightened rhetoric and hysteria around what is and what isn't democracy, about what is and what isn't freedom, about what is and what isn't the ability to lawfully assemble for the purpose of your democratic rights. All of these topics are things that I think as elected parliamentarians, this will be the only opportunity that we have a chance to contemplate these things in a way that isn't overly obscured by legal language in some kind of judicial review. It's a unique opportunity. And if we don't deal with it well, if it's perceived to be any kind of cover-up or give credence to any kind of conspiracy in nature, mark my words, we'll be back in this committee within a year and a half. That's the care that I hope that this committee deals with the undertaking. I hope and I would ask that my colleagues around the table provide a liberal interpretation to legislation that is not clear, not prescriptive.
Small
Right?
L. Small L.
Small L.
Yeah, thank you.
Yes, very small, and a place that, you know, gives us the opportunity here to continue to operate in the way in which we're operating. Again, and I don't know if the senator was in the room, but just to recap, I concede that we might not be the appropriate place to determine the legality of invoking the Emergency Act. I agree to that point. But on the first 2 points, it is absolutely contingent that we go to the preconditions, that we explore the failures of public safety frameworks, because ultimately, the decision to invoke a National Emergencies Act requires the breakdown of previous levels of government, requires the inability to adequately deal with the matters at hand. So, as we work through this work plan, again, I really implore members around this table to give this the breadth that it's going to need to unpack in a public way, to provide socio-political commentary on something that goes beyond just the legalese of, you know, whether or not invoking the act was constitutionally sound or not, because I don't think, quite frankly, when this was drafted, this situation was ever contemplated. So regardless of who's dealing with that in the judicial inquiry, I don't think they're going to be able to come up with an answer that meets the socio-political times of the moment. That's how fragile this is. And I know I've taken up some time on this, but I mean, I can't underscore, as somebody who supported this thing, how important it is that I go back to my community, letting them know that at this committee, we provided the full opportunity for a complete and thorough and careful analysis of what happened. Thank you.
Merci, Monsieur Green.
Thank you, Mr. Green. On my list, Mr. Nakvi, Ms. Bendayan, and Senator White. If there are any others, please let me know. Mr. Nakvi, please.
Thank you very much, Mr. Chair, and I appreciate the sentiment that's been expressed by various members of this committee, but I do want to remind my colleagues that we have to look at the statute under which we have been created. Our mandate is outlined in Section 62 of Emergencies Act. And Section 62 is not the only provision that is enumerated in this particular piece of legislation. There are more than one processes that have been clearly outlined in this act. It's no coincidence that it's written that way. Clearly, Parliament, when passed this legislation, contemplated two different processes to take place. And therefore, they used different language in defining those two processes, i.e. the one that's outlined in Section 62, under which we are constituted, and Mr. Varani went through the language quite well, and under Section 63, which clearly refers to as an inquiry and has very distinct and different language in terms of the scope of that particular process. Furthermore, Mr. Chair, we also should look at the entire statutory scheme that is outlined in the Emergencies Act. We are here because there was a declaration of emergency that was invoked, that was debated before the House of Commons, and approved by majority members of the House of Commons. That is why the declaration went forward. And again, that particular process is a result of the steps that are outlined in the Emergencies Act as well. Mr. Chair, I outlined all these points because to make a very specific point that there is very careful deliberation in this legislation in terms of checks and balances that Parliament had considered as to the process or the steps that must be followed when emergency is invoked. And we have been pursuing all those steps until this point. It would be wrong for us or erroneous on our part if we deviate from that process. And therefore, I would request that we look at Section 62. We understand the words that are outlined in Section 62 that are to consider exercise of powers and the performance of duties and functions pursuant to a declaration of emergency, and that is the key document that we should be considering, and how that powers were exercised and how they were performed. That is our role. So when I look at the motion in question and look at the first three bullets, I'm finding language that is very much in line with what's outlined in Section 63 of this Act, not 62. And if that process, of course, did not look at what's the circumstances that led to the declaration, then they most likely will not be fulfilling their obligation. But in this instance, we have to be quite attentive to ensure that we fulfill the duties that we've been asked of under Section 62, under which we are constituted. So I therefore request that definitely the first three bullets of the motion proposed by Mr. Motz does not meet the criteria that's outlined in Section 62 of Emergencies Act. Thank you.
Madame Bendayan.
Ms. Bendayan. Thank you, Chairman. I have a few things to say about what I just heard.
With a few of the things mentioned by my colleague, Mr. Green, and with the utmost respect, I do take issue with his reference to the fact, I believe he said we shouldn't be covering anything up here. Nobody is covering anything up here. Quite the contrary. Not only do we have this committee doing this work, we also have a full inquiry that will be put in place between now and 24 April. And so there is an interest on all sides of this House and very much on this side to continue to delve into this matter and to provide answers to Canadians. But I would remind my colleague that we also have to provide that transparency and those answers in a timely fashion. I would like to also take issue with the fact that what we are talking about here is very much dependent on the advice that we will receive from what I believe we just agreed to, and we can eventually discuss a motion to that effect, legal counsel, the either independent legal counsel, as Mr. Motz proposed, or the legal clerk or the Senate clerk. And in this discussion, I believe, again, it was my colleague, Mr. Green, referred to what he believed the legislative intent of Section 62 was. I would propose that we must hear from former Conservative Minister Perrin Beatty, who is the drafter of this piece of legislation, if we are to delve into the legislative intent of Section 62 and the work of our committee. So I would like to move at this time that we adjourn debate on this motion, that we perhaps discuss a motion which was previously circulated to invite with urgency these law clerks as well as the Honourable Perrin Beatty in order for us to get a sense of the issues that we're all speculating on, and then come back to this motion as put forward by my colleague, Mr. Motz. And so there is now a motion on the floor, to be clear, Mr. Chair, to adjourn debate.
Si je comprends bien.
If I understood correctly, Ms. Bendayan, you're suggesting that we adjourn the debate on the motion we're considering, to adjourn it and to have former Minister Beattie appear. Mr. Chairman, I have a motion to this effect, but I think we can't have two motions at the same time. Okay, I just want to make sure we're discussing the same thing. Is the motion, well, if I can do it, or if I could do it, I would, but I don't think I have a right to do it.
Donc, ça va. Alors, il y a une...
All right, there is a motion to adjourn, standing in the name of Ms. Bendayan, and that we should hear witnesses about the purpose of the act, and they may be able to clarify some things. But right now we have the motion on the adjournment. Is it unanimous, or should we have a show of hands? So, Clerk, will you please go ahead?
Debate
Adjourn.
on this.
And to call witnesses.
No, then she'll introduce.
And then you'll introduce.
I'm ready
Okay.
with that one.
Okay,
but-
thank you.
So this is a motion to adjourn debate on this motion. As we proceeded last time, I will first call the senators, beginning with the Senate Joint Chair, and then my colleague will call the members of the House. Honorable Senator Boniface. Yes. L'honorable Sénatrice Boniface vote oui.
Honorable Senator Boniface votes yes.
CP.
The Honorable Senator Carignan, no.
Votes no. The Honorable Senator Harder, PC.
Yes.
L'honorable Senator Harder vote oui. The Honorable Senator White.
Oui.
L'honorable Senator White vote oui.
I will now call the roll call for the members of the House of Commons, starting with the chairs. Monsieur Fortin.
Mr. Fortin, no.
I vote no.
Ms. Bendayan.
Oui.
Mr. Naxi.
Yes.
Mr. Varani.
Yes.
Mr. Brock.
I vote no.
Mr. Motz.
I vote no.
Yeas pour 5, nays contre 5.
Monsieur le greffier, je pense qu'il faut recompter.
Clerk, I think you're going to have to do a recount.
I got 6. 1, 2, 3, 4, 5, 6. 1, 2, 3. Who am I missing then?
Boniface, Harder, White voted. Yeah, 6 yes.
Je suis content d'avoir trouvé quelqu'un qui était pire que moi.
I'm glad to have found someone who's worse than I am at arithmetic.
Doit être avocat. Habituellement, les avocats sont mauvais.
Yeah, I think that lawyers usually are pretty bad at math.
My apologies. La motion d'adjournement est adoptée.
Oui, OK. Ah oui, 6 contre. Vous l'avez annoncé, OK. Alors,
So it's passed. Yes, I'd like to move the motion. So, Ms. Bendayan, you have a motion. Go ahead. Thank you. It's already been circulated. I'm going to read it. For the minutes, that at the next meeting of this committee, the law clerks of the Senate and the House be invited to appear before the committee to talk about the scope of its study for an hour and a half. Mr. Brock?
Had been distributed. I haven't received anything.
OK. Ça a été fait par courriel, je crois. Mais, ouais. Est-ce qu'on a... Avez-vous des copies additionnelles, Mme Bendayan?
Ça a été...
Do you have additional copies, Ms. Bendayan?
Ça a été distribué à la dernière.
Yes, it was distributed at the last meeting.
We can send it again if people want it.
Ouais, ben, si on a, ça va être plus simple.
S'il vous plaît.
Ça a été circulé et je suis en train de...
It was distributed, and now I'm going to have it distributed by the clerk. Hard copy.
Ça a été distribué à partir de... La motion?
Okay, do we have the motion? So, Ms. Bendayan, you have the floor. Okay, I'm going to go forward from the last sentence. And that the drafter of the Emergencies Act, may I get the motion by email? Yes, the clerk will send it to you. Sorry, Senator Carignan. I believe that the clerk will get it to you. The former Minister of Defense. Yes, I just want to make sure it's been sent. Has it been done, clerk?
Point of order, Mr. Chair.
Oui, juste une seconde.
Vous pouvez y aller, j'imagine que ça va rentrer dans les...
Yes, please go ahead. I'm sure I'll get it in the next few seconds. Yes, we'll wait a second. We have a point of order on the part of Mr. Brooke.
Thank you, Mr. Chair. I just require some clarification. I'm led to believe that what was distributed today on behalf of Ms. Bendayan, sorry, I may have pronounced it incorrectly, differs in the wording of what was presented at last Tuesday's committee. Unfortunately, I don't have that particular document to compare it, but I was informed by our staff that it does differ. So I'm wondering which particular amendment she is proposing, or what motion she's proposing. Which version?
Alors, le texte de la motion, Madame.
Well, the motion's text is the one you just had circulated. Yes, that's correct. And I'd like to make a clarification for my colleague, Mr. Brooke, if you'll allow. Yes, please go ahead. So I'll stop reading the motion. Yes.
Is changed in the motion circulated and is now before you is simply the 1.5 hours for each panel of witnesses, because between last meeting and today we have now, it is my understanding through all whips and Senate staff have agreed to 3-hour meetings. And so I believe that is the only change you will find between the two versions, and it reflects a matter of timing.
Okay. Monsieur Brock, ça va si on travaille?
Mr. Brock, is it all right with you if we work with the motion we have before us?
Monsieur Green, vous avez levé la main.
Mr. Green, you raised your hand. Is this a point of order, or can...
It's stemming from a point of order. I don't have to make it a point of order, but in the original motion, it does state that this is on the second portion of it, as I am to read here, that the defense minister, the former defense minister, Perrin Beatty, be invited to appear before a committee alongside other witnesses. And that's absent. And I'm just wondering, in contemplation of the previous discussion we had around outside counsel, if this might be where our first conversation around outside counsel would be included. And if that's the case, then I can see this turning into a much longer discussion. because now we're going to have to identify and engage outside counsel. Well, I think that's the debate to be had. I mean, if it's the opinion of members around the council that we would strictly allow the terms of this committee to be defined by the people who are outlined by the mover of the motion and not contemplate outside counsel, then that might have a cause for a further debate.
OK. Alors, sur le point d'ordre.
Now, on the point of order,
Mr. Chair, but I'm happy to answer it if that's helpful. Okay.
Well,
It was a 2-hour period when we were contemplating 2-hour meetings, and now that it is possible to do 2 panels within one 3-hour meeting, in 1.5 hours, we would not have time for more witnesses. But I take your point, colleague. I also would just like to clarify that there is nothing in this motion which states that we would need to come to any conclusion following this panel. Should it be your wish and the wish of the majority of the members, we can absolutely speak to outside legal counsel should the majority of this committee wish to do so. So there is nothing limiting that possibility in this motion.
Sur le point d'ordre, Monsieur Motz.
Mr. Motz, on the point of order.
I have no issue with the motion and dividing them up, quite honestly, but I have to agree with Mr. Green. I think we're talking about bringing witnesses in that are going to help us frame a scope, right? So if we're helping us frame a scope, we then need counsel. I think the counsel will help us frame a scope. And I agree that these people need to be here. I think an hour and a half each is fine. But we might be, if we're doing this for next Tuesday, we still haven't settled the legal counsel issue. And I think we need to have legal counsel here to have this conversation, because our counsel might be able to provide some sort of a balance to what we're hearing from the law clerk and from the drafter of this original legislation.
Là, je veux juste rappeler qu'on est toujours.
I'd just like to remind you that we're still on Mr. Green's point of order. And if does Mr. Green wishes to speak, Senator White, Mr. Virani, and Ms. Bendayan. It's now almost 8 o'clock, or 10 past 8, and we have this room till 9. So thank you, Mr. Motz. We'll hear from Mr. Green.
OK.
Ça va bien. Merci.
OK. Alors, Monsieur.
Yes, it's fine.
To be brief, my expectation is not that they would frame anything for us. They would give us evidence. And I would like to hear their evidence. So I don't believe it's the time to call an external legal counsel. I just want to hear their evidence about what their thinking was, and then we will make a determination about our scope.
Monsieur Virani?
So I wholeheartedly agree with the interpretation that was just provided by Senator White, but I also, I guess, just question some of the vernacular that's being thrown around. We've heard, again, talks about independent counsel or the law clerk. So again, I'm going to reiterate, I do believe the law clerk, who serves 338 members of parliament in an impartial way, is independent. He or she gives impartial advice to all members of parliament. And I would actually just cite what's in the House of Commons Procedure and Practice, 2nd edition, 2009, Appendix 10, which says that the law clerk and parliamentary counsel, quote, is responsible for providing legal advice to members of parliament, the House of Commons standing committees. That's their job. So I just want to make sure that we're all exactly on the same page in that regard. But I would reiterate Senator White's interpretation that this isn't the point final. Certainly not. We're just starting out in this journey. But it would be useful to hear from the law clerk of both the House of Commons and the Senate, and also from former Minister Beattie, so they could provide us with some evidence in respect of their views on Section 62, Section 63, what was contemplated at the time of drafting. And then it is up to the 11 of us, or however many of us there are, to make a determination about what the scope shall be. That's our decision. Merci.
Merci, Monsieur Virani.
Thank you, Mr. Virani. Ms. Bendayan.
Je constate que nous...
Well, it seems that we are debating this motion. Yes, I'm sort of bothered by this because it seemed to me we were debating Mr. Green's point of order. Well, I think we're beyond that. And that's fine. Well, I don't have an objection either. Ms. Bendayan, what I propose, Mr. Chairman, is that we go directly to a vote.
Oui, elle était sur la liste, Madame Bendayan. Non, il n'y a personne d'autre sur la liste. Ouais. Alors, tout le monde est prêt à voter?
Is everyone ready for the vote? No. Now, we're now voting on Ms. Bendayan's motion, which we have just received a few minutes ago. So, Clerk, if you could please go ahead with the vote.
So this would be the vote on the motion by Ms. Bendayan. The Honourable Senator Boniface.
Yes?
L'Honourable Sénateur Carignan CP.
Oui.
The Honourable Senator Harder PC.
Oui.
The Honourable Senator White.
Oui.
Je vais procéder maintenant à la vote pour les membres de...
Now, the vote from the members of the House of Commons. Mr. Fortin.
Je vote pour.
I vote for it. Yes.
Mr. Nakvi.
Can't help it. Oui.
Mr. Varani.
Oui.
Mr. Brock.
Oui.
Mr. Motts.
Yes.
C'est unanime, oui.
Alors, c'est unanime.
So, it's unanimous. Ms. Bendayan's motion is passed. So, Mr. Chair, given that we've just passed this motion, should we adjourn and call in the witnesses? So then we can call them to appear for the next round. Yes, I heard Mr. Chair. I don't know who it was who spoke.
Me faire appeler Mr. Chair.
I'm not used to being called Mr. Chair.
Really good job,
Okay.
Mr. Chair.
Alors, allez-y,
So
Monsieur
get used to
Nagby.
it. Mr. Chair, I would like to put forward another motion. And the motion reads as follows, that the Deputy Prime Minister and Minister of Finance, the President of the Queen's Privy Council and Minister of Emergency Preparedness, the Minister of Public Safety and the Minister of Justice be invited to appear before this committee at a date chosen by the committee members and subject to their availabilities to discuss measures invoked on February 14, 2022 under the Emergencies Act for a period of 2 hours.
Monsieur Motts, oui, s'il vous plaît.
Mr. Motts, please.
Monsieur Motts, vous avez la parole. Après, j'ai...
You have the floor, then Mr. Green, and then Senator Harder.
Mr. Brock?
Yeah, that's what...
You call me Mr. Motts.
Oh, sorry.
That's okay.
Désolé, Monsieur Brock. Oui, OK. Oui.
I'm sorry, Mr. Brock.
I have a friendly amendment to propose with respect to Mr. Nakvi's motion on the table. And it is after the word or the words Minister of Justice be invited to appear before this committee, and the amendment is at dates chosen by the committee members, subject to their availabilities to discuss measures invoked on February 14th under the Emergencies Act for a period of 2 hours, and the friendly amendment being sought is the word each. So 2 friendly amendments being sought, the word dates and the word each. Thank you.
Là, j'avais une liste de noms qui voulaient...
I have a list of people who want to speak to the main motion and the amendment proposed by Mr. Brock. Does anyone wish to speak? Yes, Mr. Green, go ahead.
If I recall, my friend Madam Bendayan suggested that an hour and a half would be required for an individual witness, and I feel like this keeps in that spirit, and we wouldn't want certainly to have a scenario where all these ministers were in for one date. So that was, I think, a very appropriate amendment, and I support it.
En termes de procédure, Monsieur Greffier.
So, Clerk, with respect to procedure, we have an amendment to the amendment. So it should be an hour and a half each rather than 2 hours?
No?
Say amendment, it's not an amendment.
Mais, OK, alors... Okay.
I was just referencing, for clarity,
Okay.
my apologies, I'll speak...
Vous nous dites ce que vous auriez aimé, mais...
You're telling us what you would have liked, but what is being moved. Can someone else, Mr. Virani?
Okay, merci, Monsieur Fortin. Donc,
Thank you, Mr. Fortin. 3 things that I'd like to underscore. First of all, we're beginning to draw up a list of witnesses. I think the ones we certainly want to call, I think they're obvious.
Obvious that you would invite the ministers. Apropos of what Mr. Brock has suggested, is that I'd raise a couple of points. One is that there is some utility in having ministers in the room at the same time, and I say that only because sometimes it can be frustrating. And I say this as a guy who's been frustrated in court at times when you don't have the right person in the witness box, and you're asking them a question and they defer it to, well, that's not under my knowledge, that's in the knowledge of person X. So person X, it'd be useful to have person X or minister X in the room at the same time so that people aren't sort of shifting responsibility for answering a certain question. And when I interpret just on crude mathematics, and again, math is not the forte of most lawyers, so work with me here. But Mr. Brock has suggested dates, and for 2 hours each. So hypothetically, if you had each minister on one of those dates, you might have 4 meetings of 2 hours. That's 8 hours. The original contemplation was 2 hours in total. But perhaps there might be a compromise that could be achievable where, since we're now in the world of 3-hour meetings, we have, instead of a total of 8 hours, a total of 6 hours. So 2 3-hour meetings, but with all of the ministers present. Or maybe in the committee's infinite wisdom, you might want 2 ministers for one of the meetings and 2 ministers for one of the other meetings. So I just put that on the floor as a suggestion. Merci.
Ouais. Alors, on en fait... C'est un amendement que vous proposez.
So are you moving an amendment, Mr. Virani? It's a general amendment, but I don't have the exact text.
Pour une période de 3 heures.
I would like to see 3-hour sessions because we already used up 3 hours for the last meeting. Okay, so we're going to decide on the amendment before us, the amendment which we add each after 2 hours. Now, do we vote on this amendment? Okay, and then we'll look at Mr. Virani's amendment. Excuse me, Chairman. Yes, I did have the raised hand function. I just want to be clear. With respect to the regulations we passed last week, I thought we had come to an hour and a half, and that there might the second round of questions for senators might have been cut. Now, with normal testimony, well, I'm wondering if 1.5 hours gives enough time to senators for a second question. Well, Senator, right now it's 2 hours each for each witness, and that's in motion number 4, which we are considering. That would mean 2 hours each. Okay, 2 hours each is fine. Now, do we vote on this amendment, Ms. Bendayan? I have a question for the clerk. I'd like to hear the amendment clearly before I vote on it. I'd like to know what we have before us exactly. The amendment of Mr. Brock, it is
Be replaced with dates, and then after the words 2 hours, the word each is added.
Each minister would appear for a period of 2 hours. Is that the amendment being proposed by Mr. Brock?
That was the original amendment. I am prepared, in light of the commentary that I have heard, to make a further suggestion that all 4 ministers appear for 6 hours. And that could be broken down into increments of 1.5, right? 2 threes. 2 3-hour periods.
And each minister would be separate?
Yes, and if permitted, I understand and I appreciate Mr. Varani's very thoughtful suggestions that from time to time, as we often see in the House in question period, that when a question is posed to a particular minister, and that minister may be present, there may be an element to the question that's better addressed by another minister. And I understand that, and I get that. However, in the conduct of this particular hearing, and while I appreciate this is by no means a trial, a civil trial or a criminal trial, we ought to strive for some level of independence. This is not going to be the proverbial cakewalk for ministers. They're going to be required to delve into some serious issues. And I don't want this to be a situation where a minister may not like that particular question being put to him or her and simply defers it to another minister to provide an answer. I think there has to be some degree of independence. I have no problem with them being in the vicinity, but being able to defer to another minister, I prefer to have the minister who is being questioned provide some response. He or she can simply say, I'm not aware, or that's not part of my jurisdiction. You better ask Minister such and such. That's okay.
OK. Est-ce que M. Brock...
Mr. Brock, from what I understand, from what you said, you're ready to withdraw your proposed amendment so that we can debate Mr. Varani's amendment. And he had moved that we should have 2 hours each. This would be a total of 6 hours. Do you agree with that, Mr. Brock? 6 hours. Yes, but six in all.
Sénateur Carignan, votre...
Senator Carignan, you wanted to say something? Yes, first of all, before we hear from you, I'd like to make sure that Mr. Brock agrees with our doing this, or do we remain with his amendment, because we're seized at the moment with Mr. Brock's amendment. Do you agree to withdrawing your amendment, sir, so that... Chairman? Mr. Chairman, I think it's still Mr. Brock's amendment. He wanted to add something to what Mr. Varani said earlier. The amendment we're considering would have each witness being heard for 2 hours. Perhaps I'm wrong, but I thought this would have us sit for 6 hours in all. Yes, can we take a short 3-minute break?
Je sais pas si je suis bon pour présider, mais cogner du marteau, ça, je pense que je peux le faire correctement. Donc, mais je comprends que...
Now, I've understood that Mr. Motz had an amendment to Mr. Brock's amendment in order to deal with this dilemma, but Senator Carignan, who had already begun speaking, if it's still relevant, Senator Carignan, please go ahead, and then I will give the floor to Mr. Motz. Yes, it's just some information I need from the clerk. I was looking in last week's notes. We were talking about speaking time for questions for each member and about the second round. And that at the end of the second turn, I believe that senators, I wanted to know if everyone uses, if everyone gets the right time for questions, would this be enough time for the minister's opening statement and for each member being able to put their questions? Thank you, Senator. Well, I believe the Senate clerk can give you information. Yes, I think if we do the math, I think that would include ministers' presentations, and they will last how long, these minister statements?
5 minutes pour les notes d'allocution.
Okay.
Yes, 5 minutes. So, clerk, 5 minutes for the minister's opening statements, and then we'll have an hour and a half to have complete rounds of questions. Does that answer your question, Senator? Yes, fine. Thank you. So now, Mr. Motz, you have the floor.
And in reference to the amendment from Mr. Brock, I wish to propose a friendly amendment that changes the wording here on this, and I believe it'll find support from across the way, that we change it to dates chosen and invoked by on February 14th under the Emergencies Act for a period of 1.5 hours each. So the translation would mean each minister 1.5 hours for a total of 6 hours between the 4 ministers. Now, those of you who are lawyers, 1.5 times 4 is 6 hours. Just so. Yeah.
Are you sure?
Yeah.
Okay.
Yeah.
Alors, est-ce qu'on a une entente?
So, are we agreed on that? Or does someone want to speak to Mr. Motz's amendment? Mr. Green.
Around their introductory remarks, I have found it immensely helpful in some other committees when ministers provide their remarks to us in advance. And that will give us time to contemplate it and have them before us, and it will obviously give the translators the opportunity there as well. So if we can put that small administrative request in, that'd be helpful. And if it require an advance 48, like kind of in 48 hours in advance, I've also been on committees where those remarks have been distributed 10 minutes before the meeting, and that's not quite as helpful.
Monsieur Green, merci.
Thank you, Mr. Green. The clerk has pointed out that in our the regulations we passed when we met March 14th, we've provided for witnesses being asked to get us their introductory remarks or their speaking notes 72 hours before the meeting. I don't think we can compel them to do it, but it is within our internal economy rules. Fine. Mr. Motz.
Oui, non, ça va, vous avez déjà fait votre... Alors...
Yes, I think you've already spoken. Thank you. We have a half hour left. Is everyone agreed that this friendly... does anyone need to speak to this friendly amendment on the part of Mr. Motz? Can we go to a vote, or is it unanimous? It's unanimous. Is that all right, clerk? So we now go to Mr. Brock's amendment as amended by Mr. Motz, which means an hour and a half for each witness for a total of 6 hours. Mr. Varani, did you wish to speak? Yes, I have another question. Have we already voted? No. It was unanimous. Right now, we're on Mr. Brock's amendment as amended by Mr. Motz. And I'm asking if anyone wishes to speak, otherwise we will vote. All right, we vote. So, recorded division, clerk?
OK. Alors, c'est unanime. Ah,
All right, it's unanimous. This is getting too easy.
on passe au point suivant.
So, next point. Mr. Varani? Well, I have another motion which has been distributed to other committee members.
We voted on the amendment. We voted on the amendment
On
for
a voté.
1.5 hours. We didn't vote on the main motion.
Moi, j'ai compris que oui, là, c'est ce que j'ai.
Well, that's what I'd asked. I wanted to vote, but I was told there was unanimous agreement to Mr. Mott's amendment as amended by you, Mr. Motz. And this is the amendment we just unanimously agreed to. I think we're ready to vote.
Non, non, non.
No. No, it's been passed.
Ben, c'est ce OK, alors on va voter. Donc,
All right. So a vote, please, clerk, on Mr. Brock's motion as amended by Mr. Motz.
oui, oui.
Je pense que la confusion, ça reste que la...
I think the question is on Mr. Motz's sub-amendment and then Mr. Brock's amendment. But now we're talking about the Mr. Nakvi's amendment. And I want to know if the committee agrees with Mr. Nakvi's motion.
La motion telle qu'elle est.
The motion as is.
Chair? Yeah. Chair, if I may?
Yeah.
Before we vote on Mr. Nakri's motion, I think it's fair that we actually adjourn that vote and adjourn that the debate on that because we're really, I think at this stage we are now receiving witness testimony when we get to this motion, and we need to sort out the legal issue first before we start dealing with witness testimony. And so I don't disagree with it. I'm just saying let's hold it in abeyance until we sort out the legal issue.
OK. Donc, il y a une motion d'adjournement.
So a motion to adjourn.
Alors, est-ce que
Does anyone want to speak to the motion to adjourn? So now we will go to a vote on Mr. Motz's motion to end debate on Mr. Varani's motion. Is that all right, clerk? So please go ahead.
Excuse me.
Oui, Monsieur White?
No, disregard.
Senator White?
So we're voting on the adjournment motion? Adjournment of debate, yeah. Adjournment of debate. The Honourable Senator Boniface.
No.
L'Honorable Sénatrice Boniface vote non. L'Honorable Sénateur Carignan, CP.
Oui.
The Honourable Senator Carignan votes yes. The Honourable Senator Harder, PC.
No.
L'Honorable Senator Harder vote no. The Honourable Senator White.
No.
L'Honorable Senator White vote no.
I will now call the members from the House. Monsieur Fortin.
Mr. Fortin? I vote yes.
Mr. Green.
I vote no. and I'll tell
Ms.
you why.
Bendayan. Mr. Nakvi.
No.
Mr. Varani.
No.
Mr. Brock.
We.
Mr. Mott.
Yes.
I have 4 yeas, 7 nays. Yeah. Yeas pour 4, nays contre 7. La motion est défiée.
The motion is defeated.
On revient donc sur la motion.
So now, Mr. Nakvi's motion, which is motion number 4, as amended.
Tel qu'amendé par
As amended by Mr. Motz and Mr. Brock. So Mr. Green, then Ms. Bendayan.
Thank you. I'm just referencing, in the wording of this that it's important in our work planning that we get a good lexical order on our scheduling. And it still feels like, in reviewing this, that we have the opportunity to pick the dates in which these folks will come in. And I think that it's obvious that we're going to need to see these folks anyways. But what I do caution is that we put the cart before the horse and have a scenario where we're boxed in on our scheduling. So I just want to earmark that the dates are at a selection of our committee.
Madame Bendayan.
Ms. Bendayan?
In the position of vehemently agreeing with Mr. Green, it was the point that I was going to make, that there is nothing in this motion that specifies when these ministers need to come before the committee. I think the committee will be, able to decide if, further to Mr. Motz's intervention earlier, if he wishes to hear from other witnesses before the ministers. I think that's entirely possible. Given the importance of efficacy in this committee, we have debated this motion, and I would move to a vote. I request the chair move the committee to vote.
Ouais. Alors, on va aller au vote. On appelle. Alors, comme il n'y avait personne d'autre sur la liste,
As there's no one else on the list, I think we can move to a vote. Clerk, if you'll please call the vote.
c'est-à-dire que sur la demande de...
We will vote on Mr. Nakvi's motion as amended by Mr. Motz and Mr. Brock. All right?
We're voting on the motion as amended.
Est-ce que c'est clair? Voulez-vous qu'on la relie?
Is that clear? Should we reread it?
Honorable Senator Boniface.
Yes.
L'honorable sénateur Carignan.
Honorable Senator Carignan.
OK, tout le monde est d'accord? Alors, c'est bon.
Okay, everyone agrees? Fine. It's unanimous. So, yes, please go ahead. So, I have another motion which states
Department of Public Safety, the Department of Finance, and the Department of Justice, and from the RCMP, CSIS, CBSA, and FinTrack be invited to appear before this committee at a date chosen by the committee members to discuss measures invoked on February 14th under the Emergencies Act for a period of 3 hours. 3. C'est un changement parce qu'on a décidé de faire.
we changed it because we decided to meet every Tuesday night for 3 hours. Senator Harder.
Just would have an observation that those are all appropriate, but I think 3 hours are too many witnesses for too short a time.
6 hours.
Can you break it up in a fashion where we would have 2 sessions of 3 hours with half of each? There's a logical separation of the two. But I'd be afraid that we wouldn't have enough time on some of the witnesses. This is going to be important ground setting.
Monsieur Virani, est-ce que ça pourrait être un...
Mr. Virani, could this be a friendly amendment? Yes. We might say
Committee on 2 dates chosen by the committee members, etc. Et à la fin for a period of 3 hours each.
Each day. Oui.
Does that work?
Ouais,
Senator
un
Harder?
total de 6 heures.
all right for 6 hours in all. Okay. Mr. Green.
So a couple of things. This list seems to be a little bit more robust than the previous one in terms of the numbers that we're having. We may need a third one. The other thing that I picked up on is that these motions are prescriptive, and so what we've done in the previous motion and what may have been interpreted in this one, and I just want clarity to put it on the record now, if we've actually made a de facto decision on the scope by suggesting that the people that are here are only here to discuss the measures invoked on February 14th. And so I would just like to ask through you to the movers if they would provide clarity on whether or not they have preemptively narrowed the scope prior to us seeking the legal interpretation that we had, I thought in good spirit, agreed we would wait to receive. And so I would just like, if I could through you, Mr. Chair, to the mover of this motion and the previous one, if they would be willing to clarify whether or not they would allow these motions to be interpreted in a manner that would be consistent with the feedback that we would receive from legal counsel, or if they have prescribed in these motions specificity that would limit the ministers and limit the members of the public safety committees that have been listed to only discussing those things on the 14th.
So, par réponse, Monsieur le Président,
So, Mr. Chairman,
that there's nothing in this motion that would limit the scope. The scope is to be determined by this committee after we hear from the people whom we want to hear from, and ultimately the determination as to what is appropriately put to the witnesses that appear before this committee will be made, a determination made on a case-by-case basis by whoever sits in that chair based on the relevance to the scope of whatever we determine the scope to be for this committee. So there's no effort through the back door or front door to limit the scope via these motions. These are simply somewhat matter-of-fact motions from groups, entities, or ministers whom it is fairly obvious we will need to hear from for the purposes of this parliamentary review committee. Merci.
Thank you, Mr. Chair. I do appreciate that. There's been lots of discussions about backdoor socialism and everything else within the House. I'm glad it hasn't bled over into this committee. If I could, though, just to put that we have the third potential date, that this isn't just 2 meetings. Is that clear?
We have an amendment as well. We'd like to add more people to that.
I guess that I still have the floor. If I could just put the question, have we determined how many dates are going to be? Because this, again, is just date. So I hope that we would have been able to rectify this in the same way we did the last one, using the same logic, and determine that we need a third date.
Ce qui est proposé, c'est...
well, what's been proposed is 2 days for 3 hours for a total of 6 hours. So over 2 days, perhaps we should put an S after date.
But I would suggest that Department of Public Safety, Department of Finance, Department of Justice, RCMP, CSIS, CBSA, and FinTrack would likely be a 3-day study that we would have to provide the time there for the 3 days. So I would move that amendment that we add a day for consideration, just so that we're not overburdening. I'm just going to share with you, this 3-hour meeting, at the end of this day has been a long one, and I'm just contemplating future evening meetings for 3 hours. I want to make sure that we have the ability to explore this stuff in a meaningful way.
OK, donc ce serait...
So we would be at 3 hours, 3 days, 3 hours each for a total of 9 hours. Is that what you're saying, Mr. Green? Is that what you are proposing? That's right. Do we agree to that? No. Yes. Mr. Brock, would you like to speak to the motion?
With respect to this particular motion,
it's in line with yours.
Introduce
Monsieur le
a mo-
Président,
an
j'ai la main
amendment on
levée
top of
aussi.
an amendment.
Mr. Chairman, I also have my hand up.
It just seems like a lot.
Plus, Matt, we want to add another one to.
Monsieur le Président, je ne sais pas s'il y a quelqu'un qui a la parole, mais je demande.
Chairman, I've asked for the floor.
Je vais vous donner la parole, M. Carignan, mais juste.
Yes, Senator Carignan, I'll give you the floor, but we have a proposed amendment, Mr. Green's. And as I understand it, we have to decide on that amendment before we hear another proposed amendment unless we have unanimous consent, in which case that would be fine. But if there is no unanimous consent on the proposed amendment, we're going to have to vote on it. Am I correct, Clerk? So it is on. Is it on this issue you wanted to speak, Senator? Yes, I'd like to speak to the amendment. Well, all right, go ahead. I looked at the main motion and the amendment. We've already heard from ministers. Now we'll be talking to officials. And we'll be doing this for several days. When will we hear from the defense associations, representatives of banks who had to do certain things, the people who've been involved in all this? I don't know if we have the proper balance. We said we wanted to strike a balance among witnesses, have people with different points of view, and it seems that we're leaning one way, and I don't know if we're going to be able to rebalance things in a way that's fair. What I'm afraid of is that we're going too quickly in drawing up a list of witnesses, government witnesses, having to do with enforcing the law, and we're going to have too many of these several days in a row. I think we might want to hear from the ministers and then try to have a better balance. Well, I have Senator Harder and then Mr. Green, but just to be clear on what Senator Carignan had to say, I've understood that we should not decide on the order in which we hear from witnesses. We're going to have to hear from these witnesses, but if I've understood, Clerk, there's no proposed order. All right. Well, if that's the context, then I'm comfortable with it. But we're going to have to talk to people who've been affected by the act.
The witnesses we're hoping to call are for our baseline foundational understanding. Secondly, in the hopes that we can bridge the difference here, can we at least start with 2 sessions of 3 hours, and we can determine whether at the end of that we need more. My fear is that we're being too prescriptive at the start. Let's open it up and in good faith advance, and if we need to call witnesses back for an additional period of time, we should do so. But we're fighting over whether or not to get started, and I think we should.
Okay. Monsieur Green et ensuite.
Mr. Green, then Mr. Motz.
Suggest, with respect to my colleague from the Senate, that there is some very logical pairings here. It would appear to me that the Department of Public Safety and the Department of Justice would make for a good themed day. It would appear to me that the Department of Finance and FinTrack would make for a good theme day. And it appears to me that the RCMP, CSIS, and CBSA would make for a third good theme day. And that was the rationale. And so it was in keeping with the line that it was baseline. I just don't want to be in a scenario where we have a mishmash of guests that aren't necessarily in keeping with appropriate themes. And so it wasn't to be obstructionist, but just to provide logic to the order and the work plan. Thank you.
Monsieur Motz, oui.
Mr. Motz?
Chair. We have potentially nine witnesses here, because we're looking at the Parliamentary Protective Service and Sergeant at Arms as well being added to this list. I think it's necessary. But there's no way, and I agree with Mr. Green, that there's no way that we can possibly, go through this. Yes, we can, Mr. Harder, we can ask witnesses to come back, but that never works as well as if we can interview them as witnesses at the very front end. There may be things that we have to clarify down the road, but it would behoove us to ensure that we allow ourselves enough time. There is no race to get this done. We have to be prudent with our time, but let's do it right the first time, and let's allow for the amount of time we need. We allowed 1.5 hours for the four from before. There's no reason why we can't pair a couple of these together and allow 1.5 hours for probably 9 to 12 hours. I would say we probably need 12 hours, 4 meetings to go through just this list, along with some other ones that we should probably add to it that are missing from this. So I would say that we can't. There's no way that we're never going to get a chance, as as Senator Karen Yale mentioned before. You can't possibly get through witnesses in a rush like this. This speaks to Mr. Green's point when we started our meeting about this can't be seen to be from the public's perception of what we're doing to be done in a way that is fast-tracked, non-transparent. We have to do our due diligence up front.
Merci, Monsieur Motz.
Thank you, Mr. Motz, Mr. Varani, and then Mr. Brock. Mr. Varani. So, Mr. Brock, you have the floor.
We should treat this in much the same way we treated the issue regarding legal counsel. My proposal is we adjourn debate on this because we're putting the cart before the horse. We don't even understand the scope yet. We haven't decided on that. So why are we pigeonholing ourselves in determining what witnesses we're calling at this point and what time we're setting aside? Right now, we're actually looking at 18 plus hours of witness testimony without even understanding the full scope of the study.
OK. Alors, il y a une motion pour adjourner.
We have a motion to adjourn. Is there unanimous consent to adjourn? Adjourn the debate on motion 5 with Mr. Green's amendment. Is there unanimous consent? So the debate on motion number 5 is adjourned. Are there any other motions?
I would move the following motion: that an order do issue for all security assessments and legal opinions which the government relied upon in determining that A, the thresholds of threats to security of Canada as defined by Section 2 of the Canadian Intelligence Securities Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required, and I have that here. Sorry. I have that here, thank you. They're a little bit wet.
Peut-être juste attendre qu'on l'ait avant. Monsieur Motz?
I'm sorry, my water spilled.
Monsieur le
The
Président,
thresholds required by Section 3A.
point au règlement.
Juste, Monsieur Motz, on va distribuer votre motion.
Chair, I'm introducing this. We won't debate it until next meeting.
OK.
Yeah. So this is an introduction to this motion. We won't be debating it today.
OK, good.
Yes. Yes, giving notice. And I'd like to read it. I'd like to read it into the record, if I may.
OK. You want to,
I want to
vous
read
voulez
it
la
into the
lire,
record.
Monsieur
Yes.
Motz? Oui. Ah, M. Mott, je voudrais la lire. Il peut la lire. Oui, oui, oui. Allez-y.
Yeah, okay. So moving on to number B, the thresholds required by sections 3A and 3B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law as required by Section 3 of the Emergencies Act. D, the emergencies measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that F, these documents shall be deposited with the law clerk and Parliamentary Council of the Senate, the law clerk and Parliamentary Council of the House of Commons, and any legal counsel which the committee may appoint in both official languages within 1 month of the adoption of this order. A copy of the documents shall also be deposited with the law clerks and any legal counsel which the committee may appoint in both official languages within 1 month of the adoption of this order, with any proposed redaction of information which, in the government's opinion, could reasonably be expected to compromise national security or to reveal details of an ongoing criminal investigation other than the existence of an investigation. H, the law clerks and any legal counsel which may be appointed by the committee shall promptly thereafter notify the co-chairs whether they are satisfied the requested documents were produced as ordered, and if not, the co-chairs shall be instructed to present forthwith, on behalf of the committee, a report to each House outlining the material facts of the situation. I, the co-chairs shall cause the documents as redacted pursuant to paragraph G to be distributed to the members of the committee and be published on the committee's website forthwith upon receipt. J, the law clerks and any legal counsel with the committee may appoint such or shall discuss with the committee at an in-camera meeting to be held within 2 weeks of the documents being distributed pursuant to paragraph I, whether they agree with the redactions proposed by the government pursuant to paragraph G, provided that upon the request of the government being when depositing the documents, the co-chairs shall be instructed to present as soon as possible on behalf of the committee a report to each House recommending that this meeting or any subsequent meeting where the discussion is continued, 1, shall, notwithstanding the order of the Senate adopted on March 3rd, 2022, not be subject to the provisions of paragraphs A to C of the order of the Senate adopted on February 10, 2022, respecting senators on standing joint committees. 2, shall, notwithstanding the order of the House of Commons adopted on March 2nd, not be subject to provisions of paragraph R of the order of the House of Commons adopted on November 25th, 2021, and 3, may, if the committee decides, be held outside of either House's precincts, but within the National Capital Region, at a location acknowledged by the government to be appropriate for the discussion and presentation of highly classified information, and K, the committee may, after hearing from the law clerks and any legal counsel which the committee may appoint pursuant to paragraph J, accept the proposed redactions or reject some or all of the proposed redactions and request the production of those unredacted documents in a manner to be determined by the committee. Please don't ask me to repeat that. Right there. Thank you, Chair.
Je comprends, M. Mott, que on...
Mr. Motz, if I understood, we will be debating this at our next meeting. Do you think we might get a copy, and we'll need an official translation in French? We did have interpretation. We need the French translation. So if it would be possible to have the document translated.
Non.
As français.
Oui, c'est ça. Oui, alors ça va être fait pour qu'on l'ait en français.
So we'll need to have it in French by tomorrow evening, so that we can discuss it on Tuesday. Thank you, Mr. Motz. Thank you, Clerk. It is now, I think, 2 or 3 minutes to 9.
Sure.
Yeah, just if we can ask, my colleague from the Senate and I were looking at everything that's been adopted. We'd like to get some instruction from the committee as what they want to do. As members may be aware, the next meeting of the committee will likely be next Tuesday from 6:30 to 9:30, and we'd like to know if it is the will of the committee to continue doing committee business, or if they want to invite the law clerks of the two chambers to appear. I'm not sure the law clerks will necessarily be ready, but we can put the request to them. We'd just like to, my colleague from the Senate and I would like to get an instruction as what the committee wishes to do with its next meeting 5 days from now. Thank you.
Mutz?
I would suggest that that's not a bad idea. However, being this is a time-sensitive, we want this information back within a month. We should probably deal with, at least with part of the meeting, with this motion, and then we can probably bring a witness or whatever that looks like, potentially. Okay.
Ouais. Oui, le légiste. Oui, donc on étudierait ce que...
So what Mr. Motz is proposing is that we discuss this motion at our next meeting on Tuesday, and then the legal clerks of the House of Commons and the Senate can appear before the committee. Are we agreed on that? Mr. Varani?
I guess the point of hearing from the law clerks is to help us determine the scope of what we're going to be looking at. So let's hear former Minister Beatty's testimony as the principal drafter of the legislation is also informative to that scope. And once we determine the scope, that'll help us address Mr. Motz's motion, because a number of those things may fall by the wayside if the scope is narrower or larger, as the case may be.
Let's do the first meeting with the 3 witnesses. 3 witnesses.
Oui, donc au prochain comité.
So at the next committee meeting, if I've understood Mr. Varani's motion, we would hear from the 2 law clerks and from former Minister Beatty. Does everyone agree? And Mr. Motz's motion will be dealt with after.
Let's deal with this motion.
Est-ce que ça, tout le monde est d'accord avec ça?
Is everyone in agreement? Clerk?
Mr. Chair, speaking with my colleague, just to temper expectations around the committee table, with essentially less than 5 days before the next meeting, we may be able to get the law clerks in there. I'm not sure we'll be able to get any other witnesses. We can try, but it is a short turnaround time, just so members understand that if we're not able to get Mr. Beatty, it may be because of the short turnaround time. We may need to invite him at a later date. Thank you.
Madame Ben-Dayan?
Ms. Ben-Dayan?
I am in agreement, and I understand the logistical constraints that the clerk just mentioned, but I don't see why we would be studying Mr. Motz's motion as a matter of priority should Mr. Beatty not be available for the second portion. There have been other motions circulated, and perhaps the committee would decide at that time which motion is most urgent to discuss in committee business. I'm not sure why we are deciding de facto today what committee business will be comprised of.
Just committee business. Committee business generally.
We just can't lose sight of this one. It's an important one.
Donc, je vois Monsieur le concierge qui se promène.
I see someone walking around at the back. We've already gone over our time at 9. At their next meeting, we'll have the 2 law clerks and former Minister Beatty, if he's available, and then we'll deal with future business, and we'll decide on which motions we want to hear. Does that suit everyone? Does everyone agree?
Ça va, monsieur?